Trademarks, these are the symbols of trademark, TM, SM, and R with the circle. We'll talk about these in a second. But what are trademarks? Trademarks are generally protection for names or trade dress. And what is trade dress? Think of it as the red Coke can. Think of it as the brown UPS truck. It is not the product and not the service itself, but the look and feel that make you believe and associate a company with a particular product or service. Let's talk about first common law trademarks versus federal trademarks. Often people ask, well, do I have to file an application to have a trademark? And the answer is no. The moment you begin using a trademark or a name in connection with a particular good, and by good I mean a physical product that gets sold, or a service, services include services as software, kind of online models, subscription models, that's a service, or legal services. The moment you begin using a name in connection with those goods or services, you have a trademark that automatically exists the moment you use it. You're going to want to take note of that date, your date of first use, because all protection in the United States with respect to trademarks is around that date of first use. It's all about who uses it first. So if you use it today and somebody uses it tomorrow, guess what? You win in most cases. And we'll talk about when you don't win. Common law trademarks, if you don't file an application, what that gives you is it gives you protection in the region in which you are using the mark. So let's say you're a coffee shop. You've got an actual physical presence on the corner in Salt Lake City, Utah. You only have protection to that name in the relevant geographic area. So that may only be Salt Lake. So what's the difference between common law and federal? Federal is provides for an actual trademark application. You can fill out an application and say, I'm using this mark in connection with these goods and services, and I began using it on this date. The moment you file a federal trademark, it is as if you are using the trademark in all 50 states. So remember, with common law, you only get protection in that small geographic area in which you're using the mark. But the moment you file this federal application, boom, you've got protection in all 50 states. So that's first reason, go ahead and file this is, if you want to take the common law approach, you're going to have to take those slow steps until you have product heavily distributed in all 50 states or locations in all 50 states. You're not going to have the same kind of protection as you do federally. So let's step back up to a broader view of trademarks again. Trademarks allow you to receive protection when you start putting money into building up goodwill in your name. Think about Coca-Cola. How much money have they poured into their branding and their name? Trademark allows them to have some confidence that somebody else can't come out with a red can and a nice white fancy script that says Coca-Cola. So the most common question I get from individuals is, well, if I file a federal trademark application, I usually will have to pay an attorney, and I have to, no doubt about it, I have to pay filing fees with the United States Patent and Trademark Office. And if I have a product, or if I have one name, and I have a logo, and I've got trade dress, each time I file for one of these applications, it's $325. And I'm a small company, and I don't have a lot of money. Why should I file? Well, there's a couple reasons. Even if you don't file, before you adopt a name on a product or in connection with your business, you need to take this. You need to make sure that you're not infringing on someone else's mark. You may have done a couple of Google searches, and you may have come up with a name that you think is really unique. But playing in the United States, we have the law of large numbers, playing against you and your name, because there are so many people at the same moment that are coming up with ideas and concepts, and generally names have somewhat to do with an idea or a concept, that the likelihood that you're adopting a name that's similar to somebody else's is actually quite high. So before you go and spend thousands of dollars branding your product, branding your company, you need to go out and see what other rights people have in those names. This will constitute web searches, looking for similar products, looking for similar names. You'll want to do Boolean searches to do wildcard searches on terms, so you can see, okay, this term is not exact, because remember, trademark protection extends not only to terms that are identical, but any term that is so similar to your trademark that it would be likely to confuse a consumer. That's the type of protection that a trademark holder receives. So it doesn't have to be identical, it only has to be similar. So that's why you're going to be searching for similar names as well. You're also going to search on the USPTO database at uspto.gov. Again, there they have various search functions that you can look and find, and inevitably there will be searches on the USPTO that won't turn up in your web searches that may be right on point. If you don't do this, you could potentially spend thousands of dollars building your brand only to find out that a few months later you receive a letter that says, I own a federal trademark to your name, you need to stop using it. And if you don't, we'll stop you from using it, and you're going to pay our attorney's fees, and you're going to pay damages. And that's very sobering to a new company. So look before you leap. Well, the flip side to that is, how would you like to be on the other side of that letter? How would you like to be able to know that A, you're not infringing on anybody else's products, and B, that nobody else can come and adopt a similar product or a similar service under a similar name? If they do, you get to protect the goodwill that you've built up so that they can't come and confuse consumers into believing that the competing product is actually your product. You can stop them, and these are the remedies and the recourse that you have when you are trademark holders. You can force others to stop using your name. You can get, if somebody actually has tangible goods, say it's a shoe, it's infringing upon your trademark, you can actually have them destroy all their goods. I mean, think about that. What if they have $1 million in inventory? You can get them to destroy $1 million in inventory. You can get them to stop from selling the infringing goods. If somebody's trying to import goods that are counterfeit, that would infringe upon your trademark, the Border Patrol, the customs agents, they can seize those goods and actually have them destroyed as well. Not to mention that you can also receive damages, money damages for lost profits that you would have received but for the infringing goods. Meaning, think about all those customers who buy your competitor's product because they thought it was actually your product. You can then recover those kinds of lost profits and damages. If you only have common law rights, most often enforcing your rights is an uphill battle. Because not only do you have to prove the damages and the infringement, but before you even get there, you have to prove that you own the trademark, that you have the first use of the trademark, that you really have priority in it, and that it's even a trademarkable term. So maybe we've gone a little backwards here, but what can be trademarked? We're living in the era of search engine optimization. People are adopting names not because they're unique, not because they might have a lot, they can build up goodwill and be so unique, but they're adopting them to perform well in search engines. And so more and more brands are adopting terms that are merely descriptive of their services. So if I offer a cleaning service, I may be cleaningservice.com or bestcleaningserviceinutah.com. Well, these are terms that are just descriptive of the services I offer. And because we don't want to give a company exclusive rights to words and terms that describe their business, those terms are not trademarkable. So if you choose words and phrases for your business that will index well or will perform well in search engines, you may be trading off your ability to protect those terms. So that maybe you are cleaningservice.com, but somebody else could be cleaningservices.com, and you would have no recourse to prevent them from using that term. So, if we know you can't register descriptive names, what can you register? Well, these would be unique and fanciful names. Think Google. Think Bing. Think Chrysler. These are names that really have no descriptive meaning, but they have come to have meaning over time as consumers associate a particular good or service with that name. Other things that cannot be registered as trademarks are geographic designations. So if you have Utah beer, well, it's a geographic designation, and so other people should be able to say that, oh, my beer is made in Utah as well. So you can't use geographic, you can't have exclusive protection of geographic terms. Same thing goes with first names. If I'm Jared, Matt, you can't use those terms and have exclusive rights to those because there are so many people with those names as well. The same goes with country flags. You can't have exclusive rights to a country flag on a product. Now that we know why we need to trademark things, what we can trademark, and these principal remedies, let's talk about the process of actually filing a federal trademark application, which in most cases I would say is kind of the wise route if you want to really have protection of your trademarks. First thing you need to do is, we discussed this earlier, is search for similar marks. When you're confident that your mark is not similar to or confusingly similar to another mark, then is the time that you're going to want to prepare your application with the United States Patent and Trademark Office, which can be prepared online at uspto.gov, and then you can file it. Searching is free. Once you file, you have to pay that $325 per trademark per class of goods and service. This application period takes a long time, generally about 9 to 12 months. After about 3 to 4 months, if there are issues with your application, you'll receive an office action. It's really a notice from the United States Patent and Trademark Office telling you that there's a problem with your application. At that point, you need to respond appropriately to the office action, and if they accept your response, then your trademark often proceeds to registration. If they reject it, well, you paid your $325 and your application will go nowhere. So just because you paid $325 and file an application doesn't mean you will obtain registration to your mark. So that brings us full circle back to these marks. TM. TM is the symbol that you use on your trademark to let the world know I'm claiming rights to this trademark. This is for goods. SN is for service mark, so in connection with services. You use these marks at any time before you have a federally registered trademark. If you've applied for a mark but it has not yet registered, you use these marks. Once you actually have a registration certificate from the United States Patent and Trademark Office, only then can you use the R symbol, which carries with it the greatest rights.